బాబా తేజస్వినావధీతమస్తు మా విద్విషావహై. ఓం శాంతి శాంతి శాంతి. అందరికీ నమస్కారం. మిత్రులారా, సగటున ఈ దేశంలో ప్రతి జిల్లాలో కూడా 700 జిల్లాలు ఉన్నాయి. ఒక 1500 ప్రమాదాలు లేకపోతే క్లెయిమ్స్ కానీ పడతాం ప్రతి జిల్లాలో. 700 జిల్లాల్లో పడే క్లెయిమ్స్ అన్ని 15,000-2,000 మధ్య ఉంటాయి. సగటున ప్రతి చోట కూడా కాంపెన్సేషన్ 10 నుంచి 20 లక్షల మధ్య అనుకున్నాం. రూపాయలు ఉన్నా కూడా లక్ష ఉన్నా కూడా సగటున. ప్రతి సంవత్సరం దీంట్లో ఇన్వాల్వ్ అయ్యేటం ఒక రాష్ట్ర బడ్జెట్ అంతా ప్రతి సంవత్సరం. మోటార్ వాహన చట్టం ఎప్పటికప్పుడు అమెండ్మెంట్స్ జరుగుతూ ఉన్నా, ఎప్పటికప్పుడు కొత్త తీర్పులు వస్తూ ఉన్నా, దీంట్లో ఉన్న భాషను అర్థం చేసుకోవడం కొంచెం కష్టమైపోయింది. ఎందుకంటే దీని మీద మనసు పెట్టి ఈ చట్టాన్ని తయారు చేసినట్టుగా కనపడదు. చాలా తప్పులు ఉన్నాయి. 1939 చట్టాన్ని తీసుకొచ్చి 88 చట్టాన్ని తీసుకొచ్చిన 88 చట్టానికి అమెండ్మెంట్స్ చేసుకుంటూ 22 నుంచి కొత్త చట్టాన్ని అమలులోకి తీసుకొచ్చిన పరభాషలో ఉన్నాయి. ఇది మనం మన మాతృభాషలో అర్థం చేసుకునేటప్పటికి చాలా పెద్ద వస్తుంది. ఆంగ్ల భాషను అత్యున్నత భాషగా, అదే విజ్ఞానంగా భావించారు. ఆంగ్లం కేవలం భాష మాత్రమే, అది విజ్ఞానంగా ఇప్పుడున్న పెద్దవాళ్ళు, సీనియర్ అడ్వకేట్స్, నేను ఇప్పుడు చెప్పబోయేది ముఖ్యంగా యువ న్యాయవాదులు. పెద్దవాళ్ళు ఆల్రెడీ రైలు పట్టాల మీద వెళ్తున్నట్టు, చిన్నగా వెళ్ళినా వేగంగా వెళ్ళినా వాళ్ళ ధోరణిలో మార్పు ఉండదు, అలానే వెళ్తారు. కానీ మీరు ఒక మంచి రహదారి మీద ఉన్నారు. మీ ఇష్టం వచ్చినట్టు వెళ్ళవచ్చు, కొత్త ప్రయోగాలు చేయవచ్చు. రైలు పట్టాల మీద ప్రయోగాలు లేవు. మీరు అన్ని రకాల విన్యాసాలు కూడా చేయవచ్చు. ఎప్పుడు పరిధిని మించి ఆలోచించాలి. కుదించుకొని ఆలోచించారంటే రాసిన వాడి ధోరణిలోనే ఉంటారు. ఇంకొక ముఖ్యమైన విషయం ఏంటంటే, మనం ఏదైనా చదవబోయేటప్పుడు ఏదైనా సైటేషన్ ఉందా, ఏదైనా జడ్జిమెంట్ ఉందా అని ఆలోచిస్తాం. ఏ జడ్జిమెంట్ కూడా నిన్నటి జడ్జిమెంట్ ఇవాళ అదే జడ్జిమెంట్ కాదు. నిన్న ఒక విషయం మీద చెప్పిన విషయం రేపు పొద్దున ఇవాళ చెప్పేటప్పుడు అట్లా ఉండదు. అందుకని చట్టం మాత్రం ఏ రోజైనా అదే, దాన్ని సమగ్రంగా అర్థం చేసుకోవాలి, సూక్ష్మంగా కూడా అర్థం చేసుకోవాలి. విద్యలు ఎన్ని అయిన విజ్ఞానం ఒకటే, భాషలు ఎన్ని అయిన భావం ఒకటే, రచనలు ఎన్ని అయిన రసధుని ఒకటే, వాస్తవము నా వారి మాట. చట్టాన్ని మీకు అర్థమైన రీతిలో, అర్థం కానప్పుడు వివరణ కోసం జడ్జిమెంట్కి వెళ్ళాలి. కానీ ప్రొవిజన్ ఆఫ్ లా చూడంగానే జడ్జిమెంట్కి వెళ్ళకూడదు. గతంలో మోటార్ వాహనం చట్టం, నేను ప్రత్యేకంగా ఇది యువ న్యాయవాదులకి మళ్ళీ ఇంకోసారి చెప్తున్నాను. నేను యువ న్యాయవాదిని, ఎందుకంటే నా ఆలోచనలు ఎప్పుడు కురవాళ్ళతో పోటీ పడుతుంది. నేను section 146. మోటార్ వాహన చట్టం మీకు మొదలయ్యేది మిగతా ఎన్ని ఉన్నా కూడా ఈ క్లెయిమ్స్కి సంబంధించినంత వరకు 146 నుంచి చదవాలి. 146 146 is a mandatory provision. You can't fly a vehicle without a policy of insurance. It's a basic requirement. You have a vehicle, you have a driver, you have petrol. But that should be kept like that. And it cannot be brought out unless you have a policy of insurance. It should be applied only when you have a policy of insurance. That is mandatory. Covering third party risks. This is also important. Who are third parties? Third parties are those that are not connected to the vehicle. A pedestrian or a third party property, something other than the persons within the vehicle and that are not connected to the vehicle. And now comes section 147. This is one section that is wrongly understood. 147 is an explanatory provision. It explains, it covers such and such things on payment of such and such premium. But it is wrongly read as if it is a policy that covers everything. Taking a policy to a vehicle does not cover all the aspects. What all the premium is paid, covering the risks of specific risks, only those are covered under the policy of insurance. I'll explain you. Everybody will be having some vehicle or other and you will be having policies. Please look into the policies that are given to you. Today, friends, we have very less time. In fact, it should have been an interactive session because of the hectic schedule. If you have any questions, please write on a slip of paper. If time permits, I will answer them. Not a question directly because it will be wasting a lot of time when the time of the bar comes later. Things. 147 again. The policy of insurance. If you look at the policy of insurance, there would be a column called schedule. First is the page is the certificate of insurance. Next page is the schedule. In schedule, there will be a small drawing with a line in the middle, a square type drawing and a line in the middle. On your right hand side in the policy, you will see TP basic. This TP basic is issued, is the mandatory which is required to cover third parties and third party risks. The premium that is paid covers third party and third party risks. Third party property risks. Third party property risk, earlier there were some adjustments in payments and, of cash and all these things. Now, the third party property risk will be mentioned, the coverage in the at the bottom of the policy copy only. For cars, they are covering some 7.5 lakhs. Where you hit a vehicle and the damage, if it's a big car, if the damage is 10 lakhs, insurance company will pay 7.5 lakhs, the rest to be borne from our body. And the other side, you see OD basic. What is OD basic? Own damage. Own damages to the vehicle. If an accident occurs, if own damages are claimed, if that is repudiated by the insurance company saying that there are some violations, What should we do? It is a, it is not a dispute under Motor Vehicles Act. It is a dispute under Consumer Protection Act. Because owner is the first party, insurer is the second party, insurer refuted the claim of the owner. So the dispute is between two persons, and very particularly Motor Vehicles Act relates only to third parties. So remembering that, this claim is a dispute under Consumer Protection Act. You have a personal action claim, compulsory PA to owner, come driver. Earlier it was compulsory PA for owner while driving. Owner if suffers loss while driving the vehicle, an amount of 2 lakhs or so was paid. The Madras High Court at one point in time interfered and said, no, this is not correct. A person having a car getting 2 lakhs and the family being left like that, it should be 15 lakhs and the premium should be 750 rupees. That was adopted by all the companies and they made it compulsory. That is called compulsory PA to owner, where now that 750 rupees fixed by the Madras High Court was reduced to some 300 odd like that. And now they are, but 15 lakhs remain the same. If the claim is repudiated, it is again a dispute under Consumer Protection Act, but not Motor Vehicles Act. There are many claims before the tribunals where the owner suffers loss and the claim is made under the provisions of Motor Vehicles Act before the tribunal. These issues have gone to the Supreme Court. Supreme Court said, though the insurance company is not liable to pay under the provisions of this act, because we pay, insurance companies pay only third party claims, not the dispute, settle the dispute between two. For saving of that time, let that amount be paid. That it was only when that judgment was passed, that was 2 lakhs of rupees to be paid, and that is the only amount the owner is entitled, the family, kith and kin of the owner of the company. That was settled in Ram Khiladi case. Where such claims for own damages are made, it should invariably, on repudiation of the claim, it becomes an dispute under Consumer Protection Act. But in 2009, on the recommendation of Supreme Court of India, IRDA had issued a circular. The inmates of a private car are not covered under policy unless premium is paid. But there is no premium treating them as third parties as per the India Motor Tariff. When such a situation arises, what would be? Supreme Court took a serious view and said, no, this is not the right way. What about the inmates of a private car? If it is a taxi, passenger risk is paid. But a private car, such risk is not paid. Then the Supreme Court said, what about this? Then IRDA issued a circular under a comprehensive policy where third-party insurance and own damages insurance are paid. It becomes a comprehensive policy or B policy, now called as package policy. When such an amount is paid, the inmates of a private car and the pillion rider on a two-wheeler are covered under the policy and treated as third parties. This is only if there is a facility created in general or as per law or the terms. No. And because that now insurance companies have withdrawn many cases on this aspect. Even if there are some other disputes, they are pending. But if the contest was only on this in appeals, many companies, all the companies, they have withdrawn the cases. There is a premium under Workmen Compensation Act covering the risk of workmen in a transport vehicle or a private vehicle. till Kalasi case, popularly known as Kalasi case, Ramashri Singh versus National Insurance Company, until Supreme Court clarified on that aspect, they said these are automatically covered under the policy of insurance. Persons in a transport vehicle are automatically covered. That was a wrong notion, wrong understanding. In Kalasi, the Lordships clarified it. Unless premium is paid, they are not entitled, the kith and kin are not entitled. Insurance company is not liable to pay compensation. They are entitled from the owner of the vehicle, that is the different aspect. All these policies, third party, own damages, personal accident, this workman compensation, such other policies that are issued to a vehicle must be different policies in general. If you take medical policy, life policy and all policies, you will get every independent policy. You take even life policy, 4 policies, there will be 4 policies, there will not be 1 policy. But as far as Motor Vehicles Act is concerned, all these policies, all these premiums that is paid by the owner of the vehicle are for the same vehicle. That's why a single policy is generated, merging all these entries into this policy.
Package policy.
Package policy, that's made a that's named as recently package policy, it was a comprehensive policy, whatever you say. Even you don't pay own damages, you take all other, that is also package. So package policy is not a correct wording. They should not have used it, but they used it and we are practicing the same. This comprehensive policy, in the old section, in 2022-147, there is a wording which was read very wrongly on many occasions till Kalasi case. Provided a policy is not required is the wording. Provided a policy is not required, a proviso after subsection 2. And the understanding, that's the reason I said we must understand it very carefully. Understanding is this policy is not required and it covers all these people. It should have been provided that a separate policy is not required. Instead of issuing 4-5 pages, 4-5 policies, issue all these are merged into this. That is to be understood looking into the policy, which we did not look into. We have been reading only from that point of view, provided a policy is not required. What about top of that? 147 is read in parts at all times. Wherever we meet, insurance company needs this aspect. Claimant advocates needs this aspect. They present that part of the provision. I present this part of the provision. And the entire pains are taken by the courts to explain it. Finally, in Kalasi case, Supreme Court said that unless premium is paid, they are not covered under policy. Premium is paid covering 6 workmen, 1 NFPP. Anyone of you? Who is NFPP?
Non-fare paying passenger. Non-fare paying passenger.
Who is he?
He may be employed by the owner of the goods. He may be owner of the goods or his employee.
NFPP is non-fare paying passenger. He is owner of goods or his representative. And the policy covers only one risk of the owner of goods. It cannot be owners of goods. 3-4 of us hire a vehicle. We load with all the household utensils, whatever people load. And because we are the 3 owners of the goods, we 3 get into the vehicle. They said no. In Choleti Parathamma case, Supreme Court clarified on this aspect. This is a case from Andhra Pradesh. Supreme Court clarified on this aspect, saying that the seating capacity of the vehicle must be Rule 252 of APMV Rules 1989. The seating capacity of the vehicle, and it was also 3-in-1, 4-in-1 Raj. Driver, cleaners for operation and owner of the vehicle. Likewise, there will be premium paid covering the risk of 6 laborers under IMT 39. I go to IMT 39 once again. What is this? Where are they? Their risk is covered at the time of loading and unloading only. They are not supposed to travel. And there is a IMT 39A which says covering the risk of 6 workmen while traveling. How are they supposed to travel? They can't sit in the body or on the top of the vehicle. They must sit in the cabin, provided they are provided with the seating capacity. In some vehicles we find big cabins where the seating capacity will be 7, 8 like that. There they can travel. So no person is permitted to travel on the top of it, or in the body of the vehicle, or sitting on the cabin. In every policy of insurance which I have said, the scheduled part, which reflects the premium that is collected by you. Every premium paid would be as per the tariff of IRDA named India Motor Tariff, that is IMT. At the bottom you find IMT endorsements with bold letters. Every policy is accompanied with those IMTs that reflect there. Those shows all these things for which the premium has been paid covering such risks as for the policies is concerned. When we go to the claim, and in Kalashi case, the policy was not placed either before the tribunal or before the High Court. The first time the policy was brought before the Supreme Court, there was an objection. Sir, this is the first time this is coming, how can we look? Supreme Court looked into the policy and it was not adjudicated by either by the tribunal or the High Court. Then Supreme Court said, no. Your claim is based on the policy, so that can be looked at any point of time. But for the policy, you can't make a claim against the insurance company. That is the reason the policy can be looked into any point of time. Now coming to another aspect of policy, persons traveling in a goods vehicle and their coverage. The very wrong wording which we always use, violation of policy. Insurance companies take a defense saying that violation of policy conditions. Yes. What are violations of policy? On every policy, if the owner of the vehicle violates them as specified under 149(2) of the earlier act, present after amendment it is 150 subsection. There are 6 violations. If these violations are that the vehicle should not be used for hire or reward, for organized racing or speed testing, not to ply without a permit, without sidecar being attached where the vehicle is two-wheeler or two-wheel vehicle, it should be permitted. Driven by a person not having an valid and effective driving license. What is the valid and effective driving license?
Valid is known for validity of the license. Effective means relevant to that vehicle which he was
Exactly. The license you hold should be a license that permits you to drive that specific vehicle. I have a license to drive a car. I can't drive a motorcycle. I can't drive a lorry. I also cannot drive a taxi of the same make of the car I have. Section 3 of Motor Vehicles Act specifies that. Necessary, right? But there are different opinions. మొదలు పెట్టినప్పుడు చెప్పాను నేను, జడ్జిమెంట్స్ చాలా కన్ఫ్యూజింగ్ ఉంటాయి వీటిని మనం ఏం అనకూడదు కాబట్టి దాన్ని అర్థం చేసుకుంటే కంటే చట్టాన్ని అర్థం చేసుకుంటే అది తేలిక వాదించడానికి సుప్రీంకోర్టు ఇట్లా చెప్పిందంటే చెప్పారు కానండి, బట్ యాక్ట్ సేస్ దిస్ అని అనే దానికి మీకు అవకాశం ఉంది. Learner's license is a license, Supreme Court said. Learner's license can never be a license according to Rule 3 of Central Motor Vehicle Rules. We are governed by Act. Today's judgment may not be tomorrow's judgment. Friends, that's why I am telling you, reading judgment is looking into dictionary where you don't understand or you have a little confusion of understanding. Then for a clarity, go to the judgment. But don't go to the judgment for all purposes. You read the act, and read the act. If you don't understand it the first instance, any subject, like you read an FIR, a criminal practitioner, what you read on different occasions, you read it number of times, you will understand it in different ways all the times you read it. An occasion arose when I was heckled by a person who said what you are saying is wrong regarding 147. I said, sir, how many times did you read this? He said 10-15 times. మీరు 10 సార్లు చదివే నాకు నన్ను ఎక్కడిగా చూస్తే 1000 సార్లు చదివాను మిమ్మల్ని చూసి ఏమనాలి? కోర్టులో రోజు చేసే పని అదే కదా. We stand for every case, we open the case, they say what does 147 say? We come and read 147. What we understand, what we did not understand yesterday or in the earlier case, after discussion, we may understand something different. So read it. Youngsters very particularly, please, whatever be the law, whatever the practice, the area you are practicing, first read the provisions. Take the support of the judgments only when you don't understand this after reading number of times, not reading once or twice. Now, coming back to policy. Policy violations we have seen. When the policy is violated and the third party, some person suffers a risk. వాడికి ఎవడో లారీ బస్సు వస్తూ ఉంది, వాడు నడుస్తూ ఉంటే వాడికి గుద్దారు, అతనికి దెబ్బలు తగిలి రేపు పొద్దున కోర్టు ముందుకు వచ్చినప్పుడు ఏమండి లారీ అతనికి డ్రైవర్కి లైసెన్స్ లేదు కాబట్టి నేను కట్టాల్సిన అవసరం లేదు అంటే అది ఇన్సూరెన్స్ కంపెనీ. కానీ క్లైమెంట్కి వాడి లారీ గుద్దేటప్పుడు నీకు లైసెన్స్ ఉందా అని అడిగి గుద్దించుకుంటారా? That is what you should analyze. Mere argument is not argument. See, ఒకటండి క్షతగాత్రుడు దెబ్బలు తగిలి ఉన్నారు, కుటుంబం ఛిద్రమైపోయింది. ఇన్సూరెన్స్ కంపెనీ may say that we are not liable to say, to pay the compensation as there is a violation of the policy. Only to that extent your argument can be. You can't say he is not entitled. Who are you to say that? What right has insurance company to say that they are not entitled for compensation? No, it cannot be. I stand for insurance companies, still I support this. It is only you can say, sir, I am not liable to pay compensation because there is a violation of the conditions of the policy. Then came this pay and recover here. He is the third party. That innocent man do not know whether there is a license or not, permit or not, whatever it be, whether he is racing or doing some nonsense. You pay him. The policy is violated by the person who is in contract with you. Go and collect from him. And there are also judgments of Supreme Court where they said, first, tribunal shall take guarantee from the owner of the vehicle to the extent that is disposed to be paid to the victims. Subsequently, that was not modified, but that was not being followed. That remains as it is. That is not followed by others. Now, again coming to policy. This is why I am discussing about more on policy. The entire claim or the compensation based on the policy. Unauthorized passengers. Who are unauthorized passengers?
Person traveling in a
Without
vehicle
having
without,
ticket. Traveling without ticket.
not
Without
not-
seating members.
Yes.
Without seating members.
That is also
One, persons, as far insurance company is concerned, persons whose risk is not covered under the policy of insurance. But general notion is concerned, persons not permitted to travel in accordance with law. Here I am talking as an insurance company advocate, I am talking only to the extent of liability. But there, yes, what if they travel as unauthorized passengers? Owner, your driver permitted him to get into a transport vehicle. Either you collected money, you did not collected money, is the second aspect. You permitted them to travel in your vehicle where the permit, they are not, there is no permit for them to allow into the vehicle. So you pay the compensation. There the pay and recovery theory will not apply. And it is not violation of policy, my friends. It is no policy. Why no policy? To the extent of policy, we go to a hotel, we take a ticket for plate meals. We go there and we see some varieties of dishes around. We ask them, they say, so sir, you will only this much and we will give you this much. Adi unna kada bhojaname kada? No. It cannot be because we cannot pay for it. And we are not liable to serve you. See, there is no policy. There is no ticket for you to serve those items. Violation of policy is only on these aspects which I discussed that are mentioned in 149(2) in the earlier act or 150 in the amended act. And as for unauthorized passengers, there is no policy. So there is no policy covering that risk. No policy in the sense not. Now, before the trial court, earlier we had that a permission under 170 of Motor Vehicles Act is required to question the negligence aspect and quantum aspect. No, that is clarified. That is clarified. Because it was there, that was only non-understanding the provision of 170. 170 is clearly understood. If he is a party to the insurance company, is a party to the proceedings, when he is a party to the proceedings, against why make an application and taking defense in asking for a leave for a defense? That cannot be. If he is a noticee, then he must make an application before the court saying, sir, I am the insurer of that vehicle and there cannot be any compensation without being an opportunity given to me. So please grant me permission and as required under 170 of Motor Vehicles Act. There were many cases that were struck down because there was no 170. After being clarified by Supreme Court, now at times there will be a question, what about 170? But nobody is serious on that because it is no longer a requirement. Trial matters are concerned. Trial matters are concerned. When we are approaching the tribunal, asking for compensation, when we are making a claim for compensation, what we plead must be the same in our request before the court. Recently we have been coming across many claims where you claim 5 lakhs, the court makes a calculation of 15 lakhs and says you are entitled for 15 lakhs. And in some cases, court says you claim 5 lakhs, so I am awarding 5 lakhs, though you are entitled for 15 lakhs. Then sir, question arose in appeal, some judges made a question.
Sir, there is any concept
How
of
are you entitled for more money when you are not agreed?
just compensation is the concept of the
Yes.
huh?
But you must,
168.
that's what they, courts are seeing, some courts are serious on this aspect. B, when you are not agreed, where is that? What you asked is paid to you. You asked 5 lakhs and they paid you 5 lakhs. How are you agreed of it? This is the question arose. Of course, the judgments are passed, but the arguments, say, what I request all the friends, while making a claim application, make the calculation in advance, a clear calculation. A lakh, that way, this way that will not count, but, and insurance company.